Good evening. It's my pleasure to welcome all of you to this year's version of the James Madison Lecture. This is a really special event on the law school's calendar. In many ways, the flagship lecture series at NYU Law School every year, and I dare say one of the leading events in legal education every year, and we're just thrilled that you're all here with us. The Madison Lecture Series began in 1960, with the first lecture being presented by Supreme Court Justice Hugo Black, where he very famously laid out his theory of the protection of the First Amendment protection of free speech as an absolute protection. And the series over the year has provided a forum for our community and others joining us to hear our nation's leading jurists present their vision of the law and its role in society. Professor Norman Dorson has directed this lecture series since 1977. The Madison Lecture Series is a wonderful tradition in part because it's an opportunity for us to welcome members of the judiciary and some of our past lecturers back to the law school. And tonight, I believe we have with us Judge Newman from the Second Circuit, who delivered the Madison Lecture in 1993. Judge Newman, are you with us? There he is, Judge Newman, welcome. And this year we have the great opportunity to welcome Judge Sandra Lynch, Judge of the United States Court of Appeals for the First Circuit, who will add to our list of distinguished speakers in this series now over many years. And we're really grateful to Judge Lynch for joining us and look forward to hearing her talk entitled Constitutional Integrity, Lessons from the Shadows. She will be introduced shortly, but let me just say on behalf of the school how thrilled we all are to welcome you here this evening, Judge Lynch. Professor Norman Dorson will introduce Judge Lynch in just a minute, but I can't resist taking this opportunity to say a few words about Norman Dorson. He is, in many ways, the embodiment of NYU Law School, our longest serving faculty member. In addition to directing the James Madison Lecture Series, he is the Stokes Professor of Law and co-director of the Hayes Civil Liberties Program. His longtime leadership of this lecture series is just one of the many ways that he has so deeply contributed to the intellectual life of this law school across many, many decades. I'm not sure whether it should embarrass me to say that he has been an integral part of this school for much longer than I have been alive. But it certainly is my great pleasure to count Norman as one of the pillars of our community here, and of course as a leader of law across this country, a renowned champion of civil liberties throughout his entire career. He's shaped the law within the profession and beyond it, and of course here at NYU has had a huge influence on legal education and how this school undertakes that. Many of the things we do at this school owe their origin to some inspiration from Norman Dorson. He was the founding director of our school's Hauser Global Law School program, and in that capacity, he helped bring leading law professors and visiting researchers and students from around the world here to NYU. And today we consider ourselves the global law school, and we have that and much more to thank Norman for. He is a true treasure of this law school, a terrific colleague, a friend of mine, and to many of us in this room, and it is my pleasure to welcome Norman to say some remarks now. You should start believing some of it.
I made the last part. Well, thank you, and thank you, Trevor. I'm very happy to see you all here. Judge Lynch is a very worthy person for this lecture series. She's been a judge for many years, has had a long career in practice, and well, I'm sure we'll be very uplifted by what she has to say. Now, there's a little history here as usual, and that is that there are several other judges from the First Circuit who've been at Madison lecturers. One is Michael Boudin, who was chief judge of the circuit. Another is Stephen Breyer, who went on to the Supreme Court, but was also chief judge of the circuit. And Frank Coffin. Frank Coffin who's a judge from Maine. Not all of you, or maybe many of you, have not heard of him, but he did something that I still think of as quite remarkable. Usually at this point, after I go on a little bit longer, not much, the speaker gets up to the microphone and delivers the Madison lecture. But Frank Coffin did not do that. He was a speaker, but he got up and walked over to there, and without looking at a note, gave a speech that was an absolute exact replica of what he would have said if he wrote it down. He didn't look at a single note for an hour, and that's longer than most lectures are, and I'm reliably told that Judge Lynch will not speak that long, and not only that, it means that we can have some questions from the floor, which we sometimes don't have. But Judge Coffin, without looking at a note, spoke for almost an hour with a remarkable fidelity to the substance and the structure of the subject, which I now forget. But in any event, I do remember the occasion. So here we have some predecessors from the First Circuit. There's one other predecessor, and that is the former Chief Judge of the First Circuit, Calvert Magruder. Magruder was a member of the circuit from 1941 to about 1965. Among his less important aspects of his career was that I was his clerk for a year, and he was a remarkable judge. Among other things, he was Justice Brandeis's first law clerk, and he showed that in his own work, which was as meticulous and careful and thoughtful as anyone could imagine. And Magruder has always been a standard for me when I think about how a judge should function. Now, here we are very fortunate in having Judge Sandra Lynch. The program states some of her many accomplishments, and I'm very, ordinarily we don't have judges who, with the exception of Judge Newman, who have done as many things as Judge Lynch. But John was one of our best lecturers, and it was great to have him here. He and I clerked together at the Supreme Court, where he clerked for Chief Justice Warren, and I clerked for Justice Harlan. And we have a few minutes thinking back to what we sometimes think of as the good old days, but who knows. In any event, John Newman, it's great to have you here, John. And anyway, here we have Sandra Lynch, who's an outstanding judge of the First Circuit. The circuit has had wonderful jurists going back 40, 50 years, including some of the ones I mentioned. So it's a great pleasure to me to introduce Judge Lynch, and we look forward to her remarks, as the Dean said.
Good evening. My thanks to Dean Morrison, Professor Dorson, and NYU for this invitation. Norman's comments bring two stories to mind. One is Frank Coffin actually wanted to be governor of Maine, and he became a judge on the First Circuit as a sort of consolation prize. So, of course, he could speak without notes. And as to why he did not become governor of Maine, Perhaps it was his snappy campaign slogan, "There's a coffin in your future." And as for Norman, what a prime example of good things who come to those who clerk for the First Circuit Court of Appeals. When Professor Dorson asked me in November 2014 to give this lecture, I thought it would be useful to talk about what happens when the executive branch, to put it politely, shadows the truth to the Supreme Court. Specifically, I wanted to tell the disturbing story of the government's lack of candor to the court in Korematsu versus United States, the 1944 Japanese internment cases. Until recently, I hadn't known that history. And indeed, it was Justice Souter who told me the history and suggested that few people knew it and it was useful to talk about it. I had no idea when I chose the subject of the speech that the topic of lying would become so much a part of the present political discourse. Perhaps the recent cover of The Economist captured the national mood best. The cover of its September 10th, 2016 issue is white, except for the dark profile of a man with a forked tongue, and bold lettering in gray, which says, "The art of the lie," an odd phrase. The feature article refers to the post-truth politics in the age of social media. The article does distinguish the legal system. It refers to legal systems as one of the institutional mechanisms which allows some level of consensus over what is true. I also had no idea when I accepted the invitation that the themes of stereotyping predicated on race, national origin, or religion would be an important current topic. Perhaps I had taken it for granted that ascribing fault to a person solely on the basis of that person's parentage without looking at the individual's own life was a thing of the past. I was concerned then, and I'm even more concerned now, about the rising level of fear from our post-9/11 war on terror. There is good reason for that fear. The photos of the beheadings by ISIS were horrifying and barbaric. Polls confirm that fear in this country is at the highest levels since the days immediately after 9/11. So as I stand here today, there is good cause to be concerned. The lessons of the past are pertinent now. In 1822, James Madison wrote, "A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both." Madison continued saying, "Knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives." Benjamin Franklin put it more prosaically in 1731, "When truth and error have fair play, the former is always an overmatch for the latter. But what happens when truth is not given fair play?" I began to worry about the problem of the courts not being given accurate information a few years ago. It happened as the extent of the National Security Agency's surveillance programs came into focus. This followed Edward Snowden's infamous leak of thousands of classified documents. We learned from Mr. Snowden that there was widespread government surveillance of electronic and phone uses by Americans. And as a result, there was a strong sense in our society that the public trust had been breached. Just months before the Snowden disclosures first broke in 2013, the Supreme Court had handed down a decision in a case called Clapper versus Amnesty International. It was a 6-3 opinion. The court, on motion to dismissed claims that the government was spying in violation of the Constitution on plaintiffs, attorneys, journalists, activists who worked with people abroad. Clapper involved a constitutional challenge to Section 702 of the Foreign Intelligence Surveillance Act of 2008. A majority of the court concluded that the plaintiffs lacked standing largely because their claims of surveillance rested on speculation about choices that would be made by independent actors in the other branches of government. Thanks in large part to Mr. Snowden's disclosures, we now know that the fear of some of the plaintiffs had some basis, and that the picture painted by the government to the court was not entirely accurate. We learned at least 2 pieces of information that call into question the government's position in Clapper. There was a question if these plaintiffs did not have standing. Did someone have standing? The Solicitor General had, believing it to be true, represented to the court that notices were in fact given to criminal defendants that warrantless surveillance had been the source of evidence against them. Such persons who got such notices would have standing. But it turned out, in fact, despite what the Solicitor General believed to be true, that prosecutors were not giving such notices. There ensued a battle in the Department of Justice between the Solicitor General and the line prosecutors. Eventually, the Solicitor General required prosecutors to give such notice. Secondly, there was some sense of the scope of the communications that were being intercepted, but it turned out that it was much broader than the picture painted by the Solicitor General to the court. This is a fact substantiated by the FISA court. The government had been engaging in much broader surveillance in what is called upstream collection. Members of Congress, 3 United States senators, wrote a letter to the Justice Department saying that the department had been less than forthright with the Clapper court. Whatever one thinks of how Mr. Snowden went about his disclosures, those disclosures have had value and a continuing impact. The Second Circuit in 2015 held that the surveillance through the telephone metadata program was illegal. One could question whether the Supreme Court, in providing the role of the Supreme Court in providing a check on the executive power, had been undermined in the Clapper case. Remember Madison, a judiciary without the facts or an independent means of acquiring them stands in danger of being manipulated by the very political branches it was designed to control. And that is what happened in Korematsu. That is a case in which the Supreme Court, by a vote of 6-3, upheld the constitutionality of a military order requiring persons of Japanese descent to remain out of certain areas and to report to detention centers. Korematsu is exactly the model of the case in which the government attorneys shadowed the truth to the court. The court upheld the military orders, and that resulted eventually in the evacuation and internment of over 100,000 people of Japanese ancestry. 70,000 of them were American citizens. The opinion itself refers to the camps as concentration camps. Many scholars have discussed Korematsu. I'm offering the perspective of a working judge. The legal canon is Korematsu was a horrible mistake. Many now accept that the internment in camps surrounded by barbed wire fences was wrong and unconscionable. Korematsu is a case that has come to live in infamy, to quote Kathleen Sullivan. But Korematsu has not been overruled by the Supreme Court, and it is cited occasionally on the point of strict scrutiny under the Equal Protection Clause. Not everyone agrees with Kathleen Sullivan. A Virginia mayor recently said about the prospect of relocating Syrian refugees to his community that he was, and I'm quoting, reminded that President Roosevelt felt compelled to sequester Japanese foreign nationals after the bombing of Pearl Harbor, and it appears that the threat of harm to America from ISIS is just as real and serious as that from our enemies then. And recent polls have shown that many voters approve of the Japanese internment. What most people don't know is that the government attorneys withheld substantial material evidence from the court. And this is what I learned from Justice Souter, who obviously had a strong interest in accuracy of information put before the court. The government's position was that the detention orders were required by military necessity in order to avoid both sabotage and espionage. Here's the background to the case. 3 months after the Pearl Harbor attacks, President Roosevelt signed Executive Order 9066. The order authorized and directed the Secretary of War and his military commanders to prescribe military areas from which certain people would be excluded. The next day, the Secretary of War designated Lieutenant General J.L. DeWitt as military commander of the Western Defense Command. In 1942, DeWitt issued a series of public proclamations designating such military areas of exclusion. Not only did the president authorize this, but Congress in turn had authorized penalties for violating these military restrictions. The prior year, the court had upheld in the Hirabayashi case, the imposition of military curfews. Interestingly, the problem which so concerned the court arose out of earlier cases involving the president's war power and the extent to which it could exceed congressional authorization. The issue came up in the German saboteur cases, but this case raised no such conflict. Both the Congress and the president had authorized those actions, a point emphasized by the court. Fred Korematsu was a native-born American citizen of Japanese descent. It was conceded he was loyal. He was criminally charged with remaining in a designated military area in violation of one of these exclusion orders. He was found guilty and was sentenced to 5 years of probation, the Ninth Circuit affirmed. Interestingly, the ACLU had been searching for the right plaintiff, and they picked Fred Korematsu. And the argument made to the Supreme Court was that his conviction was unconstitutional because it was based on nothing more than racial prejudice. He argued that the government had presented no evidence substantiating the existence of a clear and present or potential danger to our military and defense resources from citizens of Japanese pedigree or from aliens who were evacuated. Justice Black wrote for the court. He announced the strict scrutiny standard, but he concluded that it wasn't violated. Korematsu was properly convicted for a series of reasons. Let me read them to you. Because we are at war with the Japanese Empire, because the properly constituted military authorities feared an invasion of our West Coast and felt constrained to take proper security measures, because they decided that the military urgency of the situation demanded that all citizens of Japanese ancestry be segregated from the West Coast temporarily. And finally, because Congress, reposing its confidence in this time of war in our military leaders, as inevitably it must, determined that they should have the power to do just this. Black stressed that the military had to act under time pressure, so individual loyalty determinations could not be made, and that his inquiry would go no further than the time at which the military had promulgated the order. Justice Felix Frankfurter, who in private correspondence with the president had offered to resign because he wanted to be involved in the war effort, concurred. The Constitution gave the executive and the Congress this power, and that was the end of the story. Justices Roberts and Murphy dissented, saying there was no military justification for this. And Roberts noted that the very report on which the administration relied, the DeWitt report, saying espionage and sabotage, was questionable. Justice Jackson, in his usual eloquent prose, said, "What Korematsu did was," I quote, "a crime only if his parents were of Japanese birth, and that if any fundamental assumption underlies our system, it is that guilt is personal and not inheritable." Here is an attempt, Jackson wrote, to make an otherwise innocent act a crime merely because the prisoner is the son of parents as to whom he had no choice and belongs to a race from which there is no way to resign. So what was the failure of candor by the government lawyers in Korematsu? Remember, the justification was, and I'm quoting from the DeWitt report, pervasive disloyalty among those of Japanese descent, with no practicable way to separate the loyal from the disloyal. And there were instances of espionage and sabotage, particularly cases of illicit radio and light signaling along the coast. The problem is that the Justice Department knew at the time that several American intelligence agencies had flatly contradicted the factual underpinnings of DeWitt's claims. The court was never told of the contrary conclusions reached by the Office of Naval Intelligence in the Ringel Report in early 1942. The Ringel Report concluded that those of Japanese descent did not pose a serious threat to national security. The entire Japanese problem, it said, has been magnified out of its true proportion, largely because of the physical characteristics of the people. The Ringel Report said you can make individual determinations of disloyalty and recommended that. Significantly, the court was also not told that the FBI agreed with the Naval Intelligence Services. J. Edgar Hoover had personally informed Attorney General Francis Biddle that the necessity for mass evacuation is based primarily on public and political pressure rather than on factual data. Further, the court was not told that the Federal Communications Commission had informed the Attorney General that there was no evidence to substantiate DeWitt's claims of illicit signaling by Japanese Americans on the West Coast. There were some heroes in this piece. Two of the lawyers writing the brief for the government, Edward Ennis and his assistant, John Burling, attempted to add a footnote to disclose and warn the court that there was contrary information that contradicted General DeWitt's conclusions. They sent memos to Attorney General Herb Wexler and Solicitor General Fahey. Ennis emphasized the willful historical inaccuracies of the DeWitt report, and he stressed attorneys' ethical obligations to the court. Burling sent a memo pointedly stating that the FBI and FCC reports left no doubt that what DeWitt said were intentional falsehoods. In the end, there was a footnote in the Supreme Court brief, but it had been edited beyond recognition, and it did not inform the court of this contrary information. And so the footnote, in some ways, undercut its intended purpose. If that weren't bad enough, Solicitor General Fahey maintained the misleading government line even at oral argument. When he was pressed about the government's reliance on the DeWitt report and the cryptic language of footnote 2, Fahey denied that the footnote was a repudiation of the military necessity of the evacuation. The lack of candor in Korematsu is all the more egregious, given that there were no state secrets involved. This it was not necessary to protect the war effort to withhold that information. The same day Korematsu was issued, the court also issued a decision in ex parte endo, which upheld the release from the camps of interned people whom the government conceded was loyal. The effect of endo was to lead to the closing of the camps. Why am I so certain about this? Because there were 3 later investigations which concluded the same thing. In 1980, there was a commission on wartime relocation and internment of civilians established by Congress. They reached the unanimous conclusion that the DeWitt report was contradicted by substantial credible evidence from a number of federal, civilian, and military agencies. Second, the Ninth Circuit courts granted writs of coram nobis to both Korematsu and Hirabayashi and annulled the convictions. They found that the government's omission of relevant evidence and its presentation of misleading information and a selective record were deliberate. They also noted that the government was not confessing error. The government eventually confessed error 70 years after the event. In 2011, Acting Solicitor General Neil Katyal, to his credit, issued a confession of error in both Hirabayashi and Korematsu. His confession of error acknowledged that Solicitor General Fahey had known about and withheld the Ringel report from the court. One might ask whether it mattered at all to the outcome. As a working judge, I tend to believe that those disclosures would have changed the outcome. Or, at the very least, they would have changed the reasoning in the case and forced the court to be more honest about what it was doing. So finally, what are the lessons to be drawn from this shadowing of the truth? I think there is a tendency to think that the Korematsu decision was a one-off. But I don't think that's correct. The case was really about the actions taken in response to an attack on this country. We've no reason to be confident there won't be another attack on this country from terrorists. We have already been attacked once. And so the reactions of the government during the time period of the Second World War foreshadow the type of reactions we will get from the government in times of attack. Indeed, the Supreme Court has just accepted cert in a Second Circuit case involving the question of whether very high-ranking officials are entitled to qualified immunity for the choices they made in setting up policies after the attack. We should not think that the problems faced in Korematsu will never recur. We should not underestimate the executive's motivation to protect the country from terrorist attacks. There are just enormous pressures on that branch to protect the public in times of war. I don't think the courts are off the hook either. The courts should recognize that pressure and bear some responsibility for determining what the facts actually are. Recently, we've seen some signs, Justice Breyer in the Texas abortion case, in which there was very severe questioning of the justification offered by the state of Texas. Linda Greenhouse writes about this, about the importance of actually understanding the facts of a case. The Solicitor General of necessity relies heavily on the accuracy of what the Supreme Court relies heavily on what the Solicitor General says. In Clapper, the failures probably came about from the complexity of the various surveillance programs under FISA and the lack of information. The SG confesses error several times a year. Almost always, it's too late. And the Attorney General's confession of error does not overrule a case which is wrongly decided. My last lesson is the most important and the simplest. Truth matters. It matters enormously. It is the obligation of lawyers to tell the truth and to be accurate. It's also the obligation of judges to be honest and accurate. The integrity of our system of justice depends on it. There's no room in the legal system, and I'm going to quote The Economist, for post-truth politics in the age of social media. It is the job of the third branch to get it right and to allow a national consensus on what is true. We need to remember the past so we don't repeat it. Thank you very much.
Well, I just said to Judge Lynch that not only was that a wonderful lecture, but the subject of the truth being forced to be unearthed is a subject that can never be overdone. It comes up in so many different situations, not only in the courts, I might say, but in the legislature or and the executive branch. We have some time for some questions, if anyone has any. So if anyone has questions, now is the time.
If anyone's interested, by the way, Bruce Ennis, the lawyer who fought for the truth, went on to be head of the American Civil Liberties Union. Right. Yes.
That was Ed Ennis, you mean?
Yes.
Ed Ennis.
Do you feel that these courts develop an approach to cases where they subsequently discover that they have been misled, particularly by the government, and should they reopen such cases?
Look, I trust our adversary system. I'm not talking about creating a new system of truth gathering for the courts. But I do think a healthy skepticism, which takes account of the pressures the government is under, would be a wiser course of action. Let me tell you a story which does not directly answer your question, but it led to why I talked about this issue tonight. I was having dinner with a newspaper editor who had been given some information from a lawyer which would have led to the early disclosure of a huge scandal. The editor did not pursue it, and I asked him why. And he said, well, everyone knows lawyers lie. And I said, no, not all lawyers lie. But I had just read a brief in which the lawyer had lied to me. And so I didn't feel that I could just do a general defense of the bar. I do think we need to reinforce this truth-telling, not just because it's the right thing to do, but because the consequences, especially when the Supreme Court is deciding an issue, can be so horrendous. Think of all of the Japanese who lived their lives for 2 years in those camps. There is a federal judge among them, by the way. Wally Tashima of the Ninth Circuit Court of Appeals was interned as a child in Colorado, I think, where they worked on the sugar beet fields. So, any other questions? Yes. Okay.
There's a question, someone back there, yes, miss? You next.
Yes.
I was wondering if you saw any similarities between the story you described in Korematsu and something that's recently happened regarding the mandatory detention of immigrants who are sort of mandatorily detained for certain criminal convictions. The Supreme Court decided a case in 2003, Demore v. Kim, where they upheld the constitutionality of mandatory detention.
And the Solicitor General recently filed a confession of error as to some of the factual data. Sorry, I have that case in front of me right now. Nice try, though.
Yes. Yes.
To what extent might a district court be more active at, say, uncovering the truth? Because it strikes me that institutionally, it's much more difficult for a U.S. Court of Appeals or a U.S. Supreme Court to kind of, as one might say, supplement the record. And so, aren't you on one level asking the district court to, for want of a better word, kind of do a better job on this thing?
Well, of course I am. But beyond that, amicus briefs actually teach us a lot about a given area, and I have found them to be invaluable. I was a skeptic when I first went on the court because I'd written a number of amicus briefs for bar associations where they tend to say, oh gosh, sex discrimination is a bad thing. Well, yeah, it's a bad thing, but that doesn't help the court resolve the case. But more recently, I've come to the view that really good amicus briefs are a way of, if you will, supplementing the strictures on the record before the district court. You have to assume in Korematsu that if Herb Wexler and Fahey withheld this information from the court, they did so because they thought it mattered. And they did so because they thought winning the war and supporting the military was the more important objective. And in some ways, that's what I'm warning against now, that same syndrome could happen again. And I would just like the courts to be more skeptical about it.
Okay.
Our courts,
Well,
you're to Trevor. No, go ahead. Our courts have this political question doctrine. And because of that, in Korematsu, the parties were not equal. The Solicitor General was arguing a political question on spades, and the other side didn't have an
Boy, you're not getting me to go there. One thing I've wondered about is why the other reports, the Ringel report, the FBI report, why the plaintiffs never got a whiff that those reports existed. Today, we have the public disclosure laws, and we have Twitter, and we have a lot of other sources of information. So maybe we're equalizing things out more because of the enormous sources of information. But then the problem becomes, what's trustworthy? A lot of it's not trustworthy. The federal district courts do an awfully good job on evidence questions and keeping out of the record information that's simply not reliable.
Yes.
Thank you very much for coming, Your Honor. Enjoyed your lecture. Just for your information, Professor Dorset, I was in your class in the summer of 1960 as a student here.
Is that
I
right?
attended the very first lecture.
Well,
Thank you for your efforts. Now, with all due respect, I'm going to ask this question. I note in reading here that you were, it says here, you handled numerous complex litigations, including the Woburn toxic tort case, described in a civil action, which was the most fascinating literature that I've read.
Actually, I wanted, when they made a movie of it, for Jane Fonda to play me.
I appreciate that. Did that case, your involvement, or without talking about your involvement, have anything to do with withholding any information in the truth on the part of lawyers? That's my question. Thank you.
Not from the group of lawyers I worked with. Jerry Fasher, who's a great litigator, is quoted in the book as saying, "Truth, what's truth? It's at the bottom of a deep, dark well." And sometimes I'm left with the feeling that I don't know. I can only make my best understanding of it.
yes.
In light of what you said about the court's obligation to try to bring forth the truth, would you favor some kind of qualified immunity for government employees who reveal truths that their superiors would rather not have revealed?
I'm sorry, I have too many whistleblower cases in front of me.
Judge, thank you. This has been a terrific talk, and your exploration of Korematsu, I think, absolutely resonates today. So because you brought up Justice Jackson's dissent, I want to ask you about another part of his dissent that's, I think, for any reader, really very poignant. On the one hand, he dissents from the outcome in the case and would not have upheld Korematsu's conviction. But in taking that position, he urges that people not think the courts can be relied upon to protect individual liberties, especially in times of war and national security crisis. I think he's effectively saying it's one thing for the government to invoke the power of the courts to prosecute someone in a case like this, and he won't abide that. He won't underwrite with a judgment of holding the constitutionality of what the government has done there, but that the people ought not to expect that the courts can regularly be relied upon to restrain the government, including presumably to ensure that the government is telling the truth in times of war and national security crisis, especially when it's not the government invoking the power of the courts, but it would be a private citizen trying to invoke the power of the courts
Right.
to restrain its actions. And how does that factor into your thinking about really the ability of the court to ensure truth-telling, especially in times of national security crisis?
You know, Winston the truth is really so valuable, it has to be clothed in a shroud of lies. I'm sure many presidents feel that way. As to Justice Jackson, of course he's right. In many ways, the courts have been asked to take on the position of determining the morality of a society. That's beyond our capabilities. We can protect constitutional values, but we don't exist to be free-standing arbiters of the truth. What's so odd is that Jackson then goes on to be the prosecutor in the Nuremberg trials against assertions that the rules were never clearly set out, and who is this group coming to hold politicians accountable? But I suppose the Nuremberg trials also demonstrate that societies can live without their leaders telling them the truth. The outcome isn't good. I once heard Gabriel Lorca say something like, it's very important to draw a distinction between fact and fiction, that dictators regularly use fiction to remain in power. Those who oppose dictatorships have to deal with facts.
Yes.
Did Korematsu precede Brady, which required that prosecutors disclose information favorable to the defense?
Well, Korematsu's 70 years old. I'm sure Brady has come more recently. I'll tell you, given the time, I was able maybe to cope with this topic. That's a wonderful topic, but it's well beyond my knowledge. Ah, yes, Bill Pinsler, who was...
When we were in law school, Justice Clark came to school, and he was asked a question about Korematsu, because we were all young and very idealistic. And he commented about how it was a different time, that there were threats, that there were reports in the San Francisco Chronicle of planes flying over the Golden Gate Bridge and the like. My question is, in the course of your research, what happened at the district court level, where a judge is obviously surrounded by the community and surrounded by great pressure? Is there any interesting thing in the decision of the district court that would indicate anything to indicate that district court did anything other than essentially endorse what was being promulgated by the government?
I don't know, because I didn't go back to read that decision, but sociologists have done a lot of work on the climate of the time, and the climate of the time was a sort of hysteria about people of Japanese descent. No attempted distinction was drawn between citizens and aliens. And I believe that several states submitted amicus briefs to the court in Korematsu with a sort of, something has to be done about this problem, and Supreme Court, we expect you to protect the interests of the states. The dean is nodding, so apparently that's right.
Okay, I'll take one more question. See, someone? One more? Yes. Yes.
Thank you for a wonderful speech. I have a question, since we are at NYU Law, about what the implications might be for legal education. One theme that seemed to be coming up was that the person who was playing the role of making representations to the court might have themselves been hoodwinked
The Clapper case.
Are there lessons for how we should be thinking about legal education, which mostly focuses on case law and doctrine?
So this is one of my law clerks. A bunch of them are here. I'm very grateful to them for being here. I'm also very grateful for all the work they put in on this. And Dean, actually, the question is addressed to you.
I think that's an excellent question. The people in the back didn't hear it. The question is, what should this challenge that the judge has posed to us about the, I would say, the fragility of the ability to rely on truth claims within the legal system? What should that vulnerability of institutions like the judiciary teach us? And how should legal education respond to that? That's something I want to think a good long while about. The only insight I have at this point, and it's not insight, thought I have, is that a great deal of this can't be enforced externally except well after the fact. These are the kind of norms that we need to try and generate self-enforcement around. And so I would say that a part of a really great legal education is not just in the classroom, but it's in the lecture hall in the evenings. And if the current students here take anything away from tonight, it's that the ethics that we try and impart here. We have Steve Gillers here, the Dean of Legal Ethics. Where's Steve? There he is. Needs to be taken seriously as a core component of the professional preparation that we're trying to provide here. And that a lot of the sort of insistence around truth-telling is going to have to be self-enforced or internally enforced in the first instance, and policed only imperfectly and after the fact in the second instance. So that for me is a deep lesson. It's not always going to capture all of the times that we fall short. Sometimes the Solicitor General won't know that he or she has been hoodwinked until well after the fact. But some kind of insistence on the part of those attorneys to include that footnote in the brief seems to me, just as Judge Lynch said, a tale of heroism, and it's one we ought to celebrate here. Norman, I'll leave it to you to close proceedings.
Okay, thank you, Trevor, and thank you, Judge Lynch, for an excellent Madison lecture.